My lords, your honors, ladies and gentlemen, welcome to the 1980 March Special Lecture Series. Our treasurer, Mr. George D. Finlayson, is here with us and has a few words to say at the opening of this program.
Good morning, ladies and gentlemen. It's a great pleasure to be here today and welcome you all to the March Lecture Series, which this year marks the 30th anniversary of this series, which was started originally in 1950. This has always been the flagship of our continuing legal education program, and it sets the tone and the quality of what we propose to put on in the coming year. This year, we are back to bread and butter issues, which befits our commitment to supply CLE programs to those who have selected preferred areas of practice in a restricted number of subjects. It must be becoming apparent to you that with the right, which you now have, to advertise preferred areas of practice, it is inevitable that the public will perceive those who have so elected as being persons who have special confidence in these areas. We don't, as a law society, have to be concerned about persons like yourself who are attending this very detailed course, which is being put on today and the next two succeeding days. Certainly by your presence and by your interest, you are fulfilling your obligation to justify holding yourselves out as being persons who have elected states and wills and trusts as your preferred areas of practice. I'm not suggesting everybody here has done that, but those of you who have are certainly to be commended for being here today. Now, every year we always have a special committee which looks after the March Lecture Series because we want the benefit of fresh ideas every year. This March we have not been disappointed. I would like to congratulate our chairman, Marvin Catzman, and his vice chairman, Burke, Doran, on this imaginative program. I also wish to express special thanks on your behalf to our planning committee, made up of David Fuller and James Kennedy, along with our director of legal education, George Collins-Williams, and our assistant director, continuing legal education, Peter Piroff. Thank you very much.
I want to say just a word of introduction of your chairman and vice chairman of this program. Mr. Marvin Catzman, second on my right, is the program chairman this year, and Mr. Catzman came into this profession through the University of Toronto with a BA in 1959 and LLB in 1962, and weathered the 5th bar admission course, from which he graduated in 1964. He took top honors in his arts, in his academic law, and in the bar admission course where he was the Treasurer's Medal. He served as a law clerk in the year following graduation to Chief Justice McClure and then to Chief Justice Gale. Entered into active practice in 1965 and practices as a partner in the firm of Messrs. Catzman and Wall, engaged in the practice of civil litigation. He has labored long and hard in the educational work of the Law Society and of the Canadian Bar Association. He has lectured and instructed in the bar admission course, and has concerned himself and engaged in the continuing legal education work of the Society and the Bar Association and other groups. I know he has lectured at the university level in law. In 1979, Marvin Catzman was elected a bencher of the Law Society, and he now serves as Vice Chairman of the Legal Education Committee and as a member of the Admissions Committee and of the Professional Conduct Committee. Now, while I have the microphone, which is only for a very few minutes this morning, and then you will not hear from me during the program, I don't think, I should take an opportunity to introduce Mr. Burke Doran, who I don't think is on the scene, but he's going to be on the scene all day tomorrow and Saturday morning, introducing and the speakers as they appear. Now, Mr. Doran came into law through the University of McGill, where he took his arts degree, and then through the Osgoode Hall Law School, conducted here at Osgoode Hall in those days in 1961, called to the bar through the 4th bar admission course in 1963. For the first 3 years after called to the bar, he was associated with the firm of Messrs. Gowling, McTavish, Osborne, and Henderson, as that firm then was, in Ottawa. Since 1966, he has been practicing as a partner with the firm of Messrs. Lang, Missioner, Cranston, and Farquharson and Wright in Toronto, heavily engaged in civil litigation and in family law and family law litigation. He too has taken a very active part in the continuing legal education work which the Law Society and the Canadian Bar Association and others conduct in this province. In 1979, he was elected bencher of the Law Society. He is a member of the Legal Education Committee, the Legislation and Rules Committee, and the Practice and Insurance Committee. Now, these then are your chairman and your vice chairman, respectively, of this program. And the treasurer has told you that they have been appointed this year for this purpose. Unlike other CLE programming in which the Society engages, the March special lectures have a special place and a very special status in what we call CLE work. They've often been called the flagship of all CLE programming in which the Law Society engages. One thing that makes them special is the fact that each year Convocation appoints benchers to be responsible for the March special lecture programming. I hasten to add that I don't get that advantage, the advantage of having lecturers made responsible for all of the other CLE programming in which the Society takes part. In this year, with Marvin Catzman and Burke Doran, I'm sure that they would be the first two persons to declare that in their professional lives they have little experience in estate planning and administration of estates. They're civil litigants. They had the wisdom to choose estate planning and administration as the subject matter of this year's series. And they had the further wisdom to choose the planning committee, whom the treasurer has named and who will be introduced to you later, as the persons best suited and fitted to put this program together. So with that, I am going to call on Mr. Catzman and turn the conduct of the program over to him and his co-chairman. Marvin.
George, thank you very much. I propose just to make a very few introductory remarks and then to introduce our first speaker. But I should note that the March Special Lecture Series commenced in 1950, and in that year dealt with the topic of company law. Since then, the Special Lecture Series have covered the entire spectrum of legal subjects, from evidence to bankruptcy, from insurance claims to arrest and interrogation, from land use and development to jury trials, and from employment law to the Constitution. Those of you who are interested in figures and statistics may be interested to know that there have been 32 bound volumes published, numbering between their covers some 11,000 pages of text. They have been studied in every law school throughout Canada, argued in the courts, and cited with approval in the reasons for judgment of judges in every province throughout Canada. When the March Special Lecture Series began, it was the only continuing education program which the Law Society offered. 30 years later, the situation has changed dramatically. Continuing education, instead of being the occasional handmaiden of the Law Society, is now its constant companion. In the last year, for which figures are available, the Law Society sponsored not one, but 18 continuing legal education programs, at which over 4,000 persons were registered. This year's series has attracted registrants, as it normally does, from throughout Ontario, including places like New Liskeard and Kapuskasing and Kenora. And indeed, we are pleased this year to welcome 11 registrants who have come from British Columbia, Alberta, and New Brunswick to attend this lecture series. I echo the Treasurer's expression of thanks to those people who made this year's series possible, to Burke Doran, to George Collins Williams, to Peter Piroth. I want to add one name that the Treasurer, I'm sure, inadvertently forgot, and that was the name of Ruth Windelier, who is the program coordinator. I also echo the disclaimer that Mr. Collins Williams was good enough to make about my want of expertise in this field and Burke Doran's want of expertise. In order to limit our liability and spread the risk, we had the good sense to appoint two people who deserve a special vote of thanks, David Fuller and Jim Kennedy, our planning committee. You will all bear witness over the course of this and the next 2 days to the fruits of their very considerable efforts in outlining the program, in selecting the lecturers, and in monitoring the high quality of the papers which will be presented to you. I have great pleasure now in introducing our first speaker. The Honourable Madam Justice Bertha Wilson was born in Scotland. She received her LLB from Dalhousie Law School in Nova Scotia in 1958. And following a period of articles to the Honourable Mr. Justice Bissett in that province, was called to the bar there in that year. She was called to the bar in Ontario in 1959 and practiced first as an associate and then as a partner with the firm of Osler, Hoskin and Harcourt in Toronto. She was in January of 1976 appointed to the Court of Appeal for Ontario, where she has since labored with diligence and with distinction. And with her usual courtesy and grace, when we invited her to kick off our series and give the first lecture, despite a very rigorous personal schedule, she was kind enough to agree. And ladies and gentlemen, it is with gratitude and a great sense of pride that I welcome our first speaker, the Honourable Madam Justice Bertha Wilson. My lady.
Mr. Chairman, ladies and gentlemen, when I was invited by Jim Kennedy last fall to participate in the 1980 special lecture series and asked if I would speak on the subject of trustees' investment powers, I saw all kinds of exciting possibilities. And then he went on to explain that, of course, Maurice Cullity would be talking about the exercise of discretionary powers. Ralph Scane would be talking about the delegation of discretionary powers. A battery of eminent tax experts would be talking about the impact and influence of taxation on trustees' powers. And John Hodgson would be talking about the effect of conflicts of interests on the exercise of trustees' powers. And when he went on to add that, of course, we can't have any overlapping, I thought to myself, what on earth am I going to talk about? All of these things that seemed to me trespassed on my territory. But then I got the printed program. And wonder of wonders, I was first on the list. So I cast aside all my trauma and all my inhibitions and decided to enjoy myself, confident in the knowledge that all the speakers who came after me would deal in depth with the matters that I intend to touch upon lightly. The trust, as you know, was the tool of the rich, and the means whereby the wealth inherited by one generation could be passed on to the next and the next. It was essentially an instrument of conservation and preservation. And the trustee was the custodian of the fund and the guarantor of its safety. The trust has changed conceptually very little over the years, although its uses have expanded tremendously because of its flexibility. By what other means can ownership in property be split into a multitude of different kinds of interests, legal and beneficial, vested and contingent, interests in income, and interests in capital? It's little wonder that Maitland described the trust concept as the greatest and most distinctive achievement performed by Englishmen in the field of jurisprudence. And yet, despite this flexibility, the trust has, in some fundamental respects, clung very stubbornly to its traditional role of conservation. And this is certainly so in the area of trustees' investment powers. The trustees' fundamental promise was to hold the trust's property upon and subject to the trust spelled out in the instrument. The trust was a holding vehicle. Into it, the settlor put his accumulated wealth, not with any thought that the trustee was going to add to it, but that the trustee would conserve it. And the safety of the fund was the overriding consideration. And this emphasis on conservation has influenced courts and legislatures alike. The Court of Chancery, to which all trustees in England were accountable for their stewardship, evolved its own list of authorized investments, the so-called judicial list, which throughout the whole of the 18th century and into the 19th comprised exclusively government stocks and government loans, subsequently consolidated into one government stock known as consols, which yielded 3% per annum. That seems a very modest rate of interest to us today, but in those days it was viewed as a very satisfactory return on what was a safe and solid investment. You will recall that a hard lesson had been learned at the beginning of the 18th century when the great trading companies were formed and the wealthy families of England invested in what seemed at the time to be a regular bonanza, only to lose their shirts and their trust funds in the South Sea bubble. And it's no overstatement to say that it took centuries to recover from the shock of it, if indeed we have yet recovered. The trustees of the time were so nervous after that particular crash that they were refusing to make investments with the money in their hands, and the Court of Chancery had to step in and declare that they had a duty to do so. Needless to say, the governments of the day were delighted with this because the only permitted investment was consols, and they got lots of money to finance their foreign wars. And even when the judicial list was replaced by the legislative or legal list of authorized investments, the basic philosophy of conservation remained unchanged. The range of investments was extended to include first bank stock, then railway stock, then securities of municipalities of a certain size, and first mortgages on land. But it was really only after the Second World War, when the problem of inflation started to emerge, that it was realized that trust funds could no longer be preserved intact for future generations through investment in fixed income securities. At least, not if the preservation of the fund was geared to its purchasing power as opposed to its dollar amount. In 1952, the Nathan Committee in England pointed out that the problem had reached grave proportions and suggested that the legal list should be extended to allow the investment of 1/2 of the trust fund in the shares and debentures of commercial and industrial companies, provided the companies met certain prescribed tests, that they had paid a dividend on their equity capital of at least 4% in the previous 10 years, that they were of a class issued to a nominal value of not less than £1 million, and that they were quoted on the stock exchange so that a reasonable market was available to permit of ready realization of the investment. Now, many criticisms were leveled against this recommendation, but the one which probably killed it at the time was that these tests provided no real protection to the investor. The quality of management was the only true indicator of the health of a company, and no statistical techniques had been devised which could test that. There was, moreover, a supervening concern that extending the powers of trustees to equities would encourage speculation by trustees, many of whom had no special investment skills and little time to oversee their investment portfolios. It is interesting to note that as early as 1954, frustrated advisory committees in England were recommending that the whole concept of the legal list be scrapped on the basis that what had originally been designed as a safeguard had become, in a period of inflation, a major source of the erosion of trust funds. The proposal was that the legal list be replaced by a statutory prudent man rule. This suggestion, however, fell on deaf ears, and indeed it was not until 1961 that the legal list was amended to pick up the Nathan Committee suggestion and authorize the investment of 1/2 of the trust fund in the securities of private companies, which met tests very similar to those suggested by the Nathan Committee in 1952. And from then on to the present day, the history of trustees' investment powers in England has been a process of tinkering with the proportion that can be invested in equities and the prescribed tests that those equities have to meet. Now, perhaps it was the lawyer's fault that the prudent man rule was not adopted by statute at that time, because clients, on their advice, had turned to solving the problem for themselves. They simply bypassed the legal list and, by express provisions in their wills and trust deeds, conferred on their trustee the widest power they could to select investments which would best combat the erosion of the fund through inflation, while at the same time providing a reasonable income for the life tenant. Now, I've traced the development of trustees' investment powers in England because the pattern in the Canadian provinces and territories followed very closely the English pattern. And by the mid-60s, several provinces had passed legislation permitting a portion of the trust fund to be invested in equities. The portion in Ontario, as you know, is currently 35%, which seems to me to be inordinately low if the impact of present-day inflation, the so-called galloping as opposed to the creeping variety, to adopt the language of the politicians, is to be truly combated. Has the time come then for the Canadian provinces and territories to part company with the legal list and take a leaf out of the notebook of many of the states of the United States? The state of Massachusetts has never had a legal list. It never departed from the prudent man rule. And many states which did create lists have now reverted and adopted prudent man legislation similar to that of Massachusetts. It seems to me that we are ready for it in Ontario, and that the only reason we don't have it already is probably the same reason as they don't have it in England, namely the predisposition of testators and settlers to confer wide-open investment powers on their trustees in an attempt to circumvent the restrictive impact of the current legislation. Considerable and, in my opinion, very valid criticism has been directed at Section 27 of our Trustee Act, both as to the proportion which may be invested in Section 27 securities and at the dividend record test as purporting to guarantee that a company is a sound one. Dividends in some years may have been paid out of reserves. The section doesn't say that they have to be paid out of profits. A company in one of the years may, for sound financial reasons, have paid no dividend. For example, because it wanted to use the funds for expansion. Such a decision might be indicative of sound management, but it would disqualify the shares as trustee investments. So also would a decision to declare a dividend in one year, but not pay it until the next. So much for the dividend record test as a good housekeeping seal of approval. And what are we to do with the 35% split? Raise it to 75%, as they have done in the majority of the jurisdictions in the states which still retain the legal list approach? Or should we bite the bullet and adopt the statutory prudent man rule approach recommended by the Commissioners for the Uniformity of Legislation in Canada in their 1970 Model Act? The key provision in that act reads, unless a trustee is otherwise authorized or directed by an express provision of the law or of the will or of the instrument creating the trust or defining his powers and duties, he may invest trust money in any kind of property, real, personal, or mixed, but in so doing, he shall exercise the judgment and care that a man of prudence, discretion, and intelligence would exercise as a trustee of the property of others. Now, it's interesting to note that the commissioners are requiring the trustee to exercise the judgment and care that a man of prudence, discretion, and intelligence would exercise, not in dealing with his own funds, but in dealing with the property of others. The rule of prudence was, as you know, a rule of the common law which developed alongside the legal list and the terms of the trust instrument. It was not enough that the investment be authorized. It also had to be prudent. And this rule of prudence is preserved in sections 26 and 27 of our Trustee Act through the qualification, quote, but only if the investment is in other respects reasonable and proper. The problem is that the Ontario authorities leave us with a real doubt as to what the true rule of prudence is in this province. And the commissioners have sought in their Model Act to put that doubt to rest, but in a way which may only be adding to the confusion. In the House of Lords decision in Spate versus Gaunt, Lord Blackburn had expressed the opinion that in general a trustee discharges his duty if he takes all those precautions in managing trust affairs which an ordinary, prudent man of business would take in managing similar affairs of his own. Spate versus Gaunt didn't involve the propriety of an investment. It involved the right of a trustee to employ a broker to do his investing. The broker defalcated with the funds, but the House of Lords held that it was reasonable and prudent for the trustee to have employed him because an ordinary businessman would have done the same thing in investing his own funds. However, in Re Whiteley, a subsequent decision of the English Court of Appeal, the issue was the propriety of an investment made by the trustee, a mortgage on insufficient security taken from mortgagors who subsequently went bankrupt. And Lord Justices Cotton and Lindley both expressed serious concern about the test in Spate versus Gaunt. They thought it was much too wide. People do things and take risks with their own money, they pointed out, that trustees should never take with the property of others. Moreover, a person investing his own funds may have only himself to think about. He may, for example, sacrifice high income for long-term capital gain, or take risks with the capital for immediate income. But a trustee cannot do those things if the beneficiaries of income and the beneficiaries of capital are different people. Lord Justice Lindley put the test this way: the duty of a trustee is not to take such care only as a prudent man would take if he had only himself to consider. The duty, rather, is to take such care as an ordinary prudent man would take if he were minded to make an investment for the benefit of other people for whom he felt morally obliged to provide. And this more restrictive test was approved by the House of Lords. Now, what happened in Ontario? First of all, I should say that Whiteley really points up the classic tension between the prudent man rule and the even hand rule. And it is this tension between those two rules, I believe, which makes any attempt to translate the scope of trustees' investment powers into specifics so difficult, if not impossible, in the case of trusts for successive classes of beneficiaries. It has been said that the rule really isn't a prudent man rule at all. It's a prudent family provider rule, and the two may be quite different. The prudent man can obviously be completely selfish and still be prudent according to his own lights and his own needs. But the prudent provider has always to be thinking of others. Well, turning to Ontario, in Gamble, which was an application heard by Mr. Justice Mowat in Toronto Weekly Court, the learned judge applied the stricter test as stated by Lord Justices Cotton and Lindley and Whiteley. However, the Court of Appeal, 2 years later in Davies versus Nelson, reverted to the wider test, Mr. Justice Middleton stating that all a trustee was called upon to do was honestly to exercise his best judgment and take the same care of the property as he would have taken if it had been his own. The only other case I was able to find in which an Ontario judge opined upon the proper test in relation to an investment is Meeks in 1968, in which Surrogate Court Judge McCrae held that a trustee who invested in a highly speculative mortgage in Quebec violated the prudent man rule and couldn't be excused from liability under Section 35 of the Trustee Act, even although he had acted on the advice of a solicitor and a valuer, both of whom were established to his satisfaction to be competent in their respective professions. The learned surrogate court judge made no reference to either Gamble or Davies versus Nelson, but in fact applied the stricter test of Lord Justice Lindley. In effect, he adopted the family provider approach. that the trustee's duty is not to take such care as a prudent man would take if he had only himself to consider, but to take the care a prudent man would take in making an investment for the benefit of other people for whom he felt morally bound to provide. He completely ignored Mr. Justice Middleton in Davies versus Nelson. So I think we have an element of confusion here as to just what the common law rule of prudence in Ontario is. And we would certainly have to clear this up if we were going to adopt a statutory prudent man rule. I don't think the provision suggested by the commissioners does clear up the confusion. True, it makes it clear that the trustee is to conduct himself as if he were handling the property of others and not his own. But it says that he is to exercise the care that a prudent man would exercise as a trustee of the property of others. Is this saying any more than that a trustee is to act as a prudent trustee? And if so, is this not that horror of horrors, the circular definition? And does it not also import into it the same emphasis on conservation which traditionally attached to the investment powers of trustees and is no longer appropriate in a period of high inflation? Why not simply say that the trustee is to exercise the judgment and care that a man of prudence, discretion, and intelligence would exercise in investing the money of others? In other words, a simple prudent man or prudent investor rule rather than a prudent trustee rule, but a prudent investor of the funds of others, not as our Court of Appeal has left it, a prudent investor of his own funds. This would, I believe, give the trustee the desirable freedom to select investments not only to combat the erosive effect of inflation, but also to adjust the trust portfolio as and when economic conditions and the needs of the trust called for it. Now, when I speak of a trustee adjusting the trust portfolio, I touch, of course, upon another area of confusion in our law in Ontario, which would be resolved by the adoption of a statutory prudent man rule, namely the question whether or not a trustee has a duty to diversify. This was the issue that Mr. Justice Keith had to deal with in Rees-Smith in 1971, in which the trustees permitted the entire trust fund to remain in the stock of Imperial Oil, a growth stock with a very low income return. The testator's widow and life tenant under his will had been accustomed to an exceedingly high standard of living during her husband's lifetime, and asked the trustees to diversify the portfolio to provide a more substantial income for her. When the trustees refused, an application was brought to the court on the widow's behalf, asking, in effect, whether the trustees were not in breach of their duty to keep an even hand between the income and capital beneficiaries, but whether they were not also in breach of their duty to diversify. Mr. Justice Keith held that they were in breach of the even hand rule, but that they had not failed to exercise prudence in the investment of the fund by not diversifying. The trustees appealed to the Court of Appeal, which agreed with Mr. Justice Keith that the trustees had violated the even hand rule and upheld his decision on that basis, but went on to say that it was therefore unnecessary for Mr. Justice Keith to have dealt with the issue of a trustee's duty to diversify. And they ordered his answer to that question to be struck from his judgment, and of course expressed no opinion on it themselves. And this seems to be where the matter still rests. It is obviously entirely unsatisfactory. I would have thought that there was no doubt that a prudent man investing the funds of others would be obliged to diversify. How otherwise can he spread the risk of loss to the estate or trust? And certainly in most jurisdictions in the United States, trustees have been charged with such a duty, although in some states the trustee has been held not to be under a duty to diversify if there is a power to retain original assets in the will or trust. I don't think such a power would protect a trustee under our law, having regard to the Supreme Court of Canada's judgment in Fales Wolfe versus Canada Permanent Trust Company in 1977, in which the testator's estate included as to 60% of its assets shares in a company which were not readily marketable, which the trustees exchanged for shares and notes in a company with the delightful name of Inspiration Limited. Inspiration was not an authorized investment, but its stock was acquired by the trustees as a vehicle for moving into authorized investments. The will gave the trustees power to retain investments, and the trustees, thinking that they were protected by that power, retained the shares of Inspiration, which certainly didn't live up to its name. When it went bankrupt, the trustees were left with a loss of $250,000, which they were required to reimburse to the estate. The Supreme Court said, yes, the power to retain applied to the investment shares, but not if they were an unsound investment. Moreover, such a power authorizes retention only until the first available opportunity for an advantageous sale, not indefinite retention, not even retention so long as the stock appeared to the trustee to be sound. The power to retain was, in other words, simply an adjunct to the duty to convert an unauthorized investment, and not an independent power in its own right. The decision of Mr. Justice Craig and Wright, also in 1977, dealt with the same kind of problem. 50% of an estate consisting of shares in a single company and a power of retention in the will. It is clear from his judgment that Mr. Justice Craig did not think the power of retention in the right will was an adjunct power, as in the Fales case, but thought it was a wholly independent power. As Professor Waters points out in an excellent discussion of these cases in 56 Canadian Bar Review, great care has to be taken by the draftsman to distinguish between trusts and powers. But I'm sure I'm trespassing on Professor Cullity's territory here. I simply want to make the point that I believe that the prudent man rule would require a trustee to diversify, and it would, in my opinion, take a very clear, independent power of retention of original assets to negate that duty. One of the things I like about the statutory prudent man approach to investments in the United States, and it's reflected also in the section I quoted from the 1970 Model Act of our Uniformity Commissioners, is that it would clear up an even worse confusion in our law as to what are investments, by saying that a trustee may invest trust money in any kind of property, real, personal, or mixed. We would no longer have to worry about the line of authorities that says investments are not investments if they are not producing income. Trustees in the process of diversifying would be able to invest in things which the economists tell us are the only real hedge against inflation. What then are the matters a trustee has to consider in making investments for the trust fund? It seems to me that they are many and varied. First of all, things like the marketability of the investment, the length of its term, its maturity date, callability, or redeemability. Particularly, he has to be concerned about those things in relation to the duration of the trust or the dates on which any beneficial interests might fall in. He has to attempt to anticipate the value of the investment at those times in case it has to be liquidated. It will, of course, be relevant in this connection whether or not he's been given power to distribute in specie. Then he has to consider, too, the needs of the beneficiaries, particularly the income beneficiaries. Do they have earning capacity of their own? Do they want maximum income? Or will it simply add to their tax problems? What flexibility does the will or trust give with respect to encroachments for them against capital? Is it wide enough to permit the trustee to compensate the income beneficiary for a shortage of income? Strong growth stocks will obviously be a desirable investment to combat inflation, but if the trustee has no power to encroach on capital, or only a very restricted one, the income beneficiary will be prejudiced. Because of inflation, it's been said that all capital is now at risk. Is the trustee maintaining a balanced portfolio so as to maintain and, if possible, expand the capital value of the trust fund? If he invests in real estate, where will the outgoings fall under the terms of the will or trust? On the life tenant or on the beneficiaries of capital? What kind of corporate distributions are likely to be received from certain companies? Will they accrue to the life tenant or to the remainderman, or will they fall to be apportioned? There can be no doubt that the role of the trustee today is a highly sophisticated one, which brings me to the last topic I want to touch upon, and again, another area of our law that requires clarification, namely the status of the so-called super trustee. It is, I think, fairly clear that trustees, while they may appoint agents to advise and assist them, must exercise their discretionary powers personally. Yet it had become fairly common practice by the time I went on the bench to do the very kind of thing which was disapproved in Re Rogers 1928. The testator in that case, after giving his executors and trustees authority to administer his estate as they, in their discretion, saw fit, then went on to direct them to consult with and be governed by the advice of his son-in-law with respect to one of his major shareholdings, and release them from all liability for doing so. 4 out of 5 of the beneficiaries wanted the shares sold. The son-in-law said no, because since the testator's death, he had acquired a personal interest in the company. But he was not a trustee in a position of conflict. He was a person with control over the exercise of the trustee's powers who had a conflict. Mr. Justice Ord held that the court had power to remove him, and did so, even although he was not a trustee and the testator had himself appointed him. He emphasized in his judgment how undesirable it is to have trustees subject to the control of persons occupying no fiduciary relationship to the estate and consequently not accountable to the beneficiaries. He rejected, however, the submission made on behalf of the son-in-law that he was not accountable to the court or subject to its control and direction. It can't be, he said, that one who is not a trustee and has no interest whatever in the estate can occupy a position superior to that of a trustee. Obviously, for the reasons given by Mr. Justice Ord, this is a highly undesirable practice. Advisors and agents, yes, but super trustees, no. However, having regard to the very limited power to appoint agents contained in Section 20 of our Trustee Act, this is a matter now of some importance to which the draftsman should direct his attention. So many decisions to be made by today's trustees require the advice of tax advisors, investment counsel, and accountants, that it's difficult to envisage just how a trustee, unskilled in these matters, is capable of exercising an independent discretion, let alone exercising the degree of supervision over its agents that some of the case law suggests is required. It may be enough to show that the trustee applied his mind to the recommendations made to him by his expert advisors before he acted on them. But I think it would be a comfort to the non-professional trustee to see our act amended to protect him from liability for acting in good faith on the basis of this very necessary kind of advice. So, in ending, I would like to give you a challenge as estate and trust practitioners. What is it to be? Back to the drawing board for another so-called foolproof precedent, or some serious consideration to legislation more appropriate for the times? Thank you very much.